Welcome to the second chapter and the 19th lecture in this lecture series on international arbitration practice. In this lecture, we introduce the first stage of any arbitration, that is, invocation of arbitration and the response to such invocation. Before we go into the lecture, some of the viewers of the previous videos of this lecture series have felt that the audio of the recordings are feeble. We are getting this issue resolved and you'll have better audio quality hopefully from the next lecture. Till then, please bear with us and use a headphone. Thank you. Coming back to provide a brief recap, the first 18 lectures of this lecture series dealt with arbitration agreements. Broadly, arbitration clauses and submission agreements. We discussed how to draft the arbitration agreements and how to avoid pitfalls in drafting those agreements. In this chapter, we will discuss the practical aspects of arbitration invocation and response to invocation of arbitration. There is typically a notice invoking arbitration and then there is a reply to the notice invoking arbitration. Typically, again, parties appoint their arbitrators in the notice of arbitration and the reply. Again, typically, the arbitration commences with the notice of arbitration. Commencement is extremely important because it stops the limitation period from running. It is like filing a suit. Section 21 of the Indian Arbitration and Conciliation Act of 1996 states, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for the dispute to be referred to arbitration is received by the respondent. This is in sync with the prevailing position world over. For example, Article 21 of the Untitled Model Law on International Commercial Arbitration 1985 states, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for the dispute to be referred to arbitration is received by the respondent. Notice that Section 21 of the 1996 Act and Article 21 of the Model Law are identical. Institutional arbitration rules may differ on the commencement. For instance, Article 3.3 of the SIAC Arbitration Rules of 2016, that is the arbitration rules of the Singapore International Arbitration Center, states that commencement date would be the date of receipt of the complete notice of arbitration by the registrar of the institute. So it reads, the date of receipt of the complete notice of arbitration by the registrar shall be deemed to be the date of commencement of the arbitration. Similarly, Article 4, Subarticle 2 of the ICC Rules of Arbitration 2021 provides the date on which the request is received by the Secretariat shall, for all purposes, be deemed to be the date of the commencement of the arbitration. Now, as a counsel, you are all set to sign on the notice of arbitration your team is prepared so as to issue on behalf of your client, whether it be internal or external, with the expectation of earning a few million or few thousand or few lakh rupees or dollars, learning a few things in that process from your seniors and from the other side as well as from your team, and trying your best to ensure that your client wins. But before you put your signature there, be sure to do a review of how you came to this page. Your client came to you. Note that your client may be an external client or an internal client where you're working as an in-house counsel. So your client came to you, briefed you about the problem that she was facing, and then you did an analysis of A, whether setting the legal machinery in motion is the appropriate thing to do, and B, whether invoking arbitration would be the correct approach. You also did your due diligence on the possible pre-arbitral steps to be taken, whether by agreement between the parties or by applicable law. For instance, Section 12A of the Commercial Codes Act of 2015, which is a statute in India, requires parties to go for compulsory pre-arbitral mediation, or pre-suit mediation to be precise here, before the matter is taken up by the commercial court. Section 12A(1) reads, "A suit which does not contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules by the central government." So, Section 12A is an example where prior to filing a suit before a commercial court, you have to undergo pre-institution mediation. Agreements may also provide for pre-arbitral steps. About 2 decades back, pre-arbitral attempts to resolve the dispute through mediation or conciliation or even amicable negotiation were not as popular. But the commercial world has started recognizing that amicable resolution, either by the parties themselves, that is through amicable negotiations, or through third party neutrals, such as through mediation or conciliation, are cost effective and effective than litigation or arbitration. So, agreements typically include pre-arbitral steps such as good faith negotiations, mediation, or conciliation. Clauses providing for these are called as multi-tier dispute resolution clauses. We discussed about drafting arbitration agreements containing such dispute resolution methods in our previous lectures. Now coming back, before shooting the gun by issuing the notice of arbitration, you would have done your due diligence on the merits of the claim. Each claim proposed by a client would have been reviewed by a team as to the chances of success, the manner of styling the claim, alternative remedies, the reliefs, and the quantum to be claimed, etc. You would also have done your homework on whether any provisional or interim relief has to be claimed before a court or emergency arbitrator, and accordingly, you would have taken the necessary steps. If there is no requirement of urgent relief before a court or emergency arbitrator, there is no need to bother about these steps. But typically, such provisional or interim relief comes into play either as a matter of necessity or legal strategy. A common example is restraining the beneficiary from invoking the bank guarantee given by your contractor client. We will deal with these aspects when we address provisional, interim, and emergency relief. For now, we will focus on invocation of arbitration. If you are going to mention the arbitrator in your notice, you would also have approached the arbitrator as to his independence, impartiality, and availability. If you don't adopt these steps, you might end up in problems. Now, let us make a list of things that you would have done or you should do before issuing the notice of arbitration. First, the claims, the nature of the claims and amounts claimed. 2. Evidence of the claims such as documents, persons involved at the time of the transaction, performance in breach. 3. Existence of arbitration agreement and possible grounds of challenge of the arbitration agreement. 4. Applicable law of the arbitration agreement, the applicable law of the jurisdiction and the law of the contract. 5. Availability of alternative remedies such as through tribunals, courts or arbitration and the appropriate remedy. 6. Whether the claims are within the limitation period, and if not, what is the strategy to be adopted to put forth those claims. 7. Legal strategy to be adopted in the proceedings. 8. The necessity of pre-arbitral provisional relief or emergency relief before the court or an arbitral tribunal. Whether there are pre-arbitral dispute resolution processes involved and whether the requirements have been complied with. 10. Whether it is fruitful to attempt amicable settlement of the dispute. 11. Estimate of legal cost to be incurred. 12. Senior counsels, experts to be appointed or required. 13 is the arbitrator sought to be appointed, independent, impartial, and available. So, these are the aspects that you must finalize or strategize, and then you are ready to draft the notice of arbitration and issue it to the opposite party. By the way, please feel free to comment in case I have missed out on something in this checklist. Bye bye and see you in the next lecture.